Welcome to Talking Business, your straight-talking guide to dealing with corporate matters. Whether you are a private or public company, an owner-managed business or an entrepreneur, a director, company secretary or in-house counsel, this is the podcast for you. My name is Sophie Brooks and I'm a partner in our corporate team. I was a transactional lawyer for a number of years before becoming a professional support lawyer, which means I'm now responsible for know-how across our corporate team. Each month, I'll provide an update on the latest developments that matter to you, and we'll be joined by an expert to take a deep dive into a key corporate law topic. Hi everyone, welcome to July's update, roundup of recent developments. So I thought we'd start this month with a case that's been quite high profile in the press. And it was a claim that was brought against the directors of Shell plc by the environmental charity ClientEarth. So it was a claim brought, what's called a derivative claim, against the directors of Shell for breach or alleged breach of their statutory duties. And I think it's interesting because it highlights the increasing scrutiny of corporate actions in relation to climate change. But overall, hopefully, it's going to provide a bit of comfort to directors trying to make commercial decisions whilst also mitigating things like climate change risks. So I mentioned that this was a derivative claim by ClientEarth. So I guess I better start by explaining what that is. So in most cases, under English law, where a wrong has been committed against a company, it's the company itself that's going to be the proper claimant and not, for example, individual shareholders. And it's for the directors acting as the company to decide whether or not to sue. But the Companies Act provides a mechanism for shareholders to step in and bring a claim in their own name on behalf of the company. It's a derivative claim. And where that claim arises from an actual or proposed breach of duty by one or more of the company directors. So the theory is basically the directors in their own name aren't going to instruct the company to bring a claim against themselves for breach of duty. So the Companies Act says, okay, well, in that situation, the shareholders can step in and bring a claim on behalf of the company against the directors. But to prevent that procedure being abused, the shareholders have to apply to the court for permission to pursue a derivative claim. And that was the stage that ClientEarth had reached in its action against the directors of Shell. So what was the claim all about? Well, ClientEarth basically alleged that the manner in which Shell's directors were dealing with climate change risk meant that they were in breach of their statutory duties to promote the success of the company and also to exercise reasonable care, skill and diligence. In particular, what ClientEarth said was that Shell had failed to implement a strategy that aligned with the Paris Agreement on climate change or would achieve net zero by 2050. ClientEarth also said that Shell's directors were in breach of 6 supplementary duties relating to climate risk that they said were necessary incidents to the sort of accepted statutory duties on the directors. So these included things like a duty to make judgments regarding climate risk based on a reasonable consensus of scientific opinion and a duty to give appropriate weight to climate risk. Well, when it came before the court actually refused ClientEarth's application on the grounds that it had failed to establish a case that justified permission being granted. The court said that ClientEarth's evidence basically just didn't show that the actions taken by the directors in their management of climate risks were unreasonable and amounted to a breach of duty. So the judge said that there was no universally accepted methodology by which Shell might achieve its emissions reduction target, and English law respected the autonomy of directors when making commercial decisions and their judgment as to the best way of achieving results in the best interests of their members as a whole. So the court also rejected ClientEarth's introduction of those supplementary duties that I mentioned relating to climate risk. It said they were not only duties and obligations that were inherently vague, but they were also incompatible with the well-established principle that basically it's for the directors themselves to determine, acting in good faith, how best to promote the success of their company. And when managing the business, Shell's directors would be required to consider a range of competing considerations, and it wasn't for the court to interfere with board decisions on how those competing interests and considerations should be balanced. So it's been an interesting case. I suspect it might not be the last we hear of it. And I think also as concerns about climate change increase, we're probably going to see more shareholder activism in this area. But it does, I think, help sending a clear message that derivative actions can't be used as a method for imposing a particular shareholder's own climate or indeed other policies onto the company. Policy decisions are for the directors to take. They decide how to deal with the risks and challenges facing their company. And I think this case gives some comfort to directors that a court won't interfere with board decisions when they're made in good faith and promote the success of the company for the benefit of its members as a whole. No doubt, I think Shell's directors had weighed up lots of factors when deciding how best to deal with the climate related risks that their company faced. And ClientEarth's belief that the directors had adopted the wrong strategy in relation to those risks wasn't sufficient for the court to interfere with the board's decisions. But as I say, it might not be the last we hear because ClientEarth has been granted an oral hearing where the decision to refuse permission for the derivative claim will be considered. I think it's probably pretty unlikely that the court will change its original decision, but any additional insights into how the court's going to deal with the issues raised could be useful both to directors and also to shareholder activists alike, as they're looking for uh, alternative ways of holding directors and companies to account. So Shell PLC is a publicly listed company. So the next sort of update that I'm going to mention is going to be relevant to them because it relates to the UK's insider dealing regime. So there are two separate regimes for this in the UK. There's a criminal one, and then there's also a civil one. And basically, what's happened recently is that some changes have been made to the criminal insider dealing regime in order to broadly align the types of securities and the markets on which a criminal insider dealing offence can be committed with those that apply to the civil market abuse regime. So, when we're looking at the criminal offence, that applies to anyone who has inside information on securities or issuers of securities companies, and they have that information as an insider, and then they deal in those securities where the price of their securities would be affected by the public release of the inside information, um, or they encourage somebody to deal in those securities, or they disclose inside information outside of the proper performance of their employment or office or profession. So you have to have inside information about a company, and that's information that, if publicly disclosed, would affect the price of their securities. And then you have to either deal in them or encourage somebody to deal in them or disclose that inside information. All of those are criminal offences. So previously, those criminal offences only applied to a fairly limited range of securities, so mainly shares and debt securities, and then also certain instruments relating to those securities. And that list hadn't been updated for a long time, and it was much narrower in range than the securities that were caught by the civil market abuse regime under the UK's market abuse regulation. So the other difference was that the criminal offence could only be committed on a fairly small number of named regulated markets. And again, that list of regulated markets was also much narrower than the relevant markets under the civil regime, and it was also actually out of date because some of the markets had merged or ceased to exist since that list was originally put together. So, as I say, the changes that have been made have basically updated the criminal insider dealing regime and aligned it much more closely with the civil regime. So, instead of being restricted to named regulated markets, the criminal offence is now going to apply to securities that are traded on any UK, EU, or Gibraltar regulated market, multilateral trading facility, an MTF, or an organised trading facility, an OTF, and then also on any market established under the rules of NASDAQ, the US NASDAQ market, or the Swiss exchange, or the New York Stock Exchange. So those multilateral trading facilities and organised trading facilities weren't previously in scope of the criminal offence, subject to a few exceptions, and their inclusion, along with those inclusions of the other markets like the New York Stock Exchange, means that now there are over 400 trading venues that are within scope of those criminal market abuse offences. The changes, as I mentioned, also expand the type of securities that are going to be covered by the criminal insider dealing offence. So it now applies not only to shares and bonds, which was under the previous regime, but also includes derivatives, so things like futures, options, credit default swaps, as well as units in collective investment schemes. So I don't think this change is particularly controversial. And in fact, if anything, it's probably long overdue. There were recommendations made back in 2015 for the changes to be made. And since then, the Financial Conduct Authority has issued various warnings about an increasing number of suspected insider dealing cases. So we've got those two regimes much more closely aligned now, and it'll be interesting to see how that develops and whether, in fact, the number of criminal prosecutions increases as a result of that expanded regime. Okay, so finally, I thought I would just pick up on another case, and this one's to do with what's called unfair prejudice. So it's a High Court case, and it was quite useful because they summarised the test for a shareholder to bring a successful petition on the grounds that a company's affairs have been conducted in an unfairly prejudicial manner. So the default position for UK companies is majority rule. But obviously, that can leave the minority at the mercy of and open to abuse by the majority. So, the Companies Act contains what's called an unfair prejudice remedy that basically helps to protect the minority in that situation. And it does that by giving them the ability to challenge a majority decision that is in some way unfair or inequitable, even if actually, technically, it might be lawful. So this recent case, it was called the For Fitness Investment Holdings Limited case. And what was useful about it was that the judge set out a summary of the sort of various hurdles that a person has to overcome in order to bring a successful unfair prejudice claim. And there were 6 steps to this. So the judge said, firstly, the claimant has to have standing to bring the petition. And that can only be done by a member of the company. So you've got to be a member in order to bring a petition for unfair prejudice. Secondly, the particular acts or omissions that you're complaining of must consist of or involve the management of the company's affairs. Then, thirdly, either those acts or omissions must be unlawful or the particular conduct must be inequitable. Then, fourthly, the claimant must have suffered prejudice. So that could be economic prejudice, but it could also take non-economic forms such as loss of office, that kind of thing. Then fifthly, the prejudice complained of must relate to the claimant's interests as a member of the company. But in relation to that, the judge did say, well, you shouldn't construe that too narrowly or technically. but it does still have to relate to the claimant's interests as a member. And then finally, the prejudice has to be unfair. Unfortunately, there's no handy list of unfair acts or categories of unfair acts, but the judge said that a useful test here was to ask whether the exercise of the power or rights in question would involve a breach of an agreement or understanding between the parties where it would be unfair to allow that agreement or understanding to be ignored. So, a good place to start when you're thinking whether any particular conduct was unfairly prejudicial is to ask whether the members had departed from what they had actually agreed. So, in this recent case, it related to a company that had been set up in 2019 to operate a gym franchise, basically. So, a chap called Mr. Hashmi became a shareholder and director of the company, and that company also had two other directors. Under the company's articles of association, a director could be removed from office by a majority of the other directors. Mr. Hashmi also entered into a consultancy agreement with the company, and that agreement was terminable either on 30 days' notice or immediately if there had been a particular default event. So that was back in 2019. Then we get to late February 2021, and one of the other directors, Mr. Lorimer Wing, took steps to lock Mr. Hashmi out of the company's IT systems. Remember, Mr. Hashmi was a director. And then on the 2nd of March, Mr. Lorimer Wing sent an email to Mr. Hashmi stating that he had been removed as a director of the company and that the consultancy agreement had been terminated by mutual agreement. So Mr. Hashmi brought a claim for unfair prejudice, and he did so on the basis that his removal as a director was ineffective, as he hadn't been notified in his capacity as either a director or a shareholder of any proposed resolution to remove him as a director or of any board or general meeting. So remember, he was a director, he was a shareholder of the company, but he just received this email from another director saying, we've removed you as a director. But so Mr. Hashmi was saying, well, how could you have done that? You didn't hold a shareholders meeting, you didn't hold a directors meeting, or if you did, you didn't give me notice of them. So Mr. Hashmi said, well, if my removal was ineffective, then Mr. Lorimer Wing was wrong to exclude Mr. Hashmi from the company's IT systems. It was wrong to remove him as a director, and it was wrong to breach the consultancy agreement by immediately terminating it. So the judge found that Mr. Hashmi had not been removed as a director. He said, well, that there's been no notice of a board meeting given to the directors, no agenda has been circulated, and there had been no meeting at which the directors had been able to communicate with each other in the manner required by the articles. So if a meeting had been properly convened, properly held, then Mr. Hashmi could have attended, he could have objected to the resolution. And remember, there were three directors, so he could have attempted to persuade the third director that Mr. Lorimer Wing was wrong and effectively to vote with Mr. Hashmi in defeating that resolution to remove him as a director. So, because of all of those sort of faults in the process, the court said, well, there's been no valid resolution of the board of directors to remove Mr. Hashmi. So the court went on to say that Mr. Lorimer Wing's failure to convene a properly constituted board meeting was unreasonable. It was also unfair of him to ignore the company's constitution, to exclude Mr. Hashmi from information about the company, and also to terminate the consultancy agreement in breach of its terms. And then the judge said also that Mr. Lorimer Wing had breached an understanding. Remember, looping back to that test, has there been a departure from the understanding between the members? Well, here the judge said that Mr. Lorimer Wing had breached the understanding between him and Mr. Hashmi that all major decisions would be made by them jointly. So, looking at all of that, the judge said that all amounted to conduct which was unfairly prejudicial to Mr. Hashmi. So, in this particular case, the judge didn't actually give any order following that finding. He made that finding, but then he didn't sort of go on, and he basically invited the parties to go away and agree what they were going to do, or and then come back to the court, or come back if they couldn't agree. So when you're looking at an unfair prejudice petition, the court has a wide range of remedies available to it if that petition is successful. But the most common one is that the majority must buy out the minority shares at fair value. And part of the reason the judge didn't make a direct order in this case was because, in fact, sort of after the petition had been issued, Mr. Lorimer Wing had supposedly made an offer to buy out Mr. Hashmi's shares. So the parties were going to go away and discuss that effectively. So that's the most likely result. So if you're a minority shareholder and you're thinking of complaining about unfairly prejudicial conduct by bringing this kind of a petition, you need to bear that in mind, that the most likely outcome is that you're going to be have your ordered to sell your shares at fair value to the majority. But an unfair prejudice petition isn't the only course of action available to an aggrieved minority. They could also perhaps consider asking for the company to be wound up. Obviously, that's a fairly drastic course of action, but they could ask for it to be wound up on the just and equitable ground. Or, as we saw with the first case that we talked about, the Shell case, a shareholder could perhaps bring a derivative claim in the name of the company against those directors that are controlling its affairs in order to compensate the company rather than the minority shareholder for any loss that it has suffered as a result of their actions. So I hope you found that update interesting, and I'll see you next month. Thank you for listening to Talking Business. To find out more about the series, please visit gatelyplc.com/talkingbusiness. From there, you can subscribe for all updates, meet our speakers, and get more information on all of the topics being discussed.